Okay, we'll go ahead and call Senate, Fed, and State to order. First thing on the agenda is bill requests. First thing I want to state, we do have a withdrawal of a bill request Senator Longbine made a few days ago. The RS number is 22 RS 3229. I don't think we need approval to withdraw that, but I just want to make everything aware, and it'll be in the minutes. Do we have any bill introductions? Not seeing any, we'll go ahead and move on. Senate Bill 192, we'll go ahead and open the hearing. Mike, you want to give us an overview on it?
Mr. Chairman, members of the committee, you've got Jason's explanation of the bill, but what I'm going to do is just hit the highlights of the bill quickly. The bill authorizes courts to issue an order requiring a defendant to relinquish all firearms in their custody or control or possession and any concealed carry license upon the court's issuance of a protective order or upon the conviction of a defendant for domestic battery or any misdemeanor domestic violence. The firearms would be relinquished to the sheriff, or you could relinquish them to a federal firearms dealer. And the bill outlines the procedures for how this would take place and the time frame for relinquishment. The duration would be until basically they had their rights restored and so on, or if the protective order was eliminated. There is a new crime established in Section 2 on page 4. It's unlawful for a person to possess a firearm or concealed carry license while there is a relinquishment order in effect. The violation of this is a level 8 non-person felony. Section 3 deals, it's on page 5, deals with judgments and when court orders a sentence and so on for convictions on page 6 for convictions of domestic battery or any misdemeanor domestic violence. The court shall issue a relinquishment order, and there's an amendment to the protection from abuse orders that appear in 60-3107 on page 6, which again, the actual amendments on page 9, upon the issuance of a qualified protective from abuse order, the court shall issue a relinquishment order, and the similar amendment is made in Section 5 dealing with protection from stalking and sexual assault or human trafficking and so on, where the court would issue a relinquishment order. If you've got questions, I'll try and answer them.
Questions? Senator Fascadeau.
Thank you, Mr. Chairman. Thank you, Mike. So I certainly support the legislation, but a quick question. So my sheriff, Jeff Easter, contacted me over the break and had a couple of questions. And so so this order is made in the court to relinquish the firearm. So how would then, unless that person is there in the courtroom and he's willing to relinquish, how then would that procedure go for the sheriff's department or whomever to meet at their house to have them relinquish them, or are they just going to voluntarily bring the firearms back? How does that work in the bill?
Well, there's a provision for voluntary relinquishment where they could give it to the sheriff or a federal firearms dealer, and I assume well, anyway, I won't get into that, but or if they're not physically present when the order is issued, there's procedures for the sheriff or a law enforcement officer to go out and basically confiscate the weapons and the concealed carry license if they have one.
Thank you, Mr. Chairman, and I think I'll, with the proponents, kind of further elaborate on my question. Thank you.
Other questions or comments? Thanks, Mike. Okay, we'll go ahead and move. First step on the proponents, and we've opened the hearing, is Minority Leader Sykes, Kansas Senate.
Good morning. Thank you so much. And I want to say thank you to the chair for having a hearing on this bill. And I will be brief with my remarks, but in 2018, the legislature passed legislation to ensure that Kansas was in compliance with federal law requiring the relinquishment of firearms in cases of qualified protective orders, domestic battery convictions, and domestic violence misdemeanors. So this is a trailer bill just putting in place that we have that mechanism of how to do this because they are currently not supposed to have possession of firearms. And this has led to some confusion in our communities, inconsistent application of the law, and in some cases, grievous consequences to victims of domestic violence. In 2019, the Kansas Coalition Against Sexual and Domestic Violence Partners responded to over 37,000 crisis hotline calls and served over 69,000 individuals. Our law enforcement agencies reported significant increase in domestic violence incidents during the height of the pandemic. And so the legislation that we passed in 2018 with bipartisan support was clear, and it had a goal of reducing domestic violence, domestic gun violence. So this bill just creates a path to achieving that goal and ensuring that violent individuals do not have access to the lethal force that they can and statistically are likely to use to hurt our families and communities. And so this is really just putting us in compliance with federal law. But I would be happy to answer questions at the appropriate time.
Are you going to hang around, or?
I do need to go, so if I have.
Okay, let's go ahead and ask questions. And Senator Fascadeau.
Thank you, Mr. Chairman. Thank you, Senator Sykes, for bringing this legislation. I know this is something near and dear to you. Can you give us an example of a situation occurring of why we really need this legislation?
Thank you, Senator Fascadeau. And I know in the heart of your district in Wyandotte County, in Wichita, in Sedgwick County, we've had numerous newspaper articles about how it is people who have been convicted. They are not supposed to have those firearms, but because we don't have a consistent process in place for them to relinquish those guns, that our domestic violence victims are being murdered.
Okay, you done?
Thank you, Mr. Chairman.
Further questions? Thank you.
All right, thank you so much again. Thank you for having a hearing, and I hope you pass it favorably because we are honestly just trying to put ourselves in compliance and protecting Kansas, so thank you very much.
Sorry. Kansas Representative Hoya.
Thank you, Mr. Chair and committee members. As the previous proponent stated, a very important law went into effect in 2018, and I went back and looked at the historical documents on HB 2145, and I did submit written testimony to this committee in favor of that bill as an advocate, and so I really appreciate the opportunity to stand before you today as one of your colleagues and continued efforts to support women and families and their safety in Kansas, as well as survivors of domestic violence and gun violence who have been advocating for years and years. SB 192 is an enforcement mechanism for that bill. Currently, there isn't a streamlined process that clearly explains how this relinquishment should occur upon these convictions. So the individuals convicted in court are already prohibited from purchasing or possessing firearms. And if they are not there, then they would have to transport a firearm to the law enforcement or a federally licensed gun dealer. And so this written order would provide them what they need, the paperwork they need, should they be pulled over in that process if they are voluntarily complying with that law. So it's really important for them to have that written order upon their conviction so that they can clearly and safely relinquish that firearm. And yes, if that process, so they have 24 hours to take it to the sheriff or FFL, and then 48 hours to provide the written proof of relinquishment back to the courts. And if in the case that that doesn't happen, then law enforcement would get involved. And it is very important. We know that domestic violence continues to impact public safety in our state, to have to ensure that those who are in violation of the law, in fact, turn in guns that they may already have once they become, for the time period that they are prohibited from purchasing and possessing those firearms. So I would ask for your support to once again stand in favor of the safety of Kansans, and I'm happy to answer any questions.
Do we have any questions? Senator Fascado.
Thank you, Mr. Chairman. Representative, thank you for thoroughly explaining this bill from your perspective. So when in the bill, is there language, you know, the receipt you're kind of talking about of once they relinquish the firearms, is there anything in there that gives that person who is relinquishing the firearm a time that they would be able to then purchase a gun or get that gun back?
Yeah, and that is spelled out in our law, so they already would know how long they are in fact prohibited from purchasing and possessing firearms. Depending on the conviction, it can vary in time. I think it's usually around 3 to 5 years. But the proof of relinquishment information is in the bill. I don't know if the revisor can help me quickly find that where it says what they have to provide. But it does spell out in there the information that is included on that when they take it back within the 48 hours. It should be where there's a 48 in here. Go
ahead, Mike.
If you'd repeat the question, I'm sorry, I was reading the criminal statute.
We're looking for where it defines what is included in the proof of relinquishment.
The order itself or what?
No, they have within 24 hours after the order. Sorry, but there is, oh, here it is. I think it's page 4.
I think is where the bill is. You've got basically 24 hours after service. If you were in person at the time the order was issued, within 48 hours after issuance of the relinquishment order, the defendant, subject to the order, shall file one or more proofs of relinquishment and so on. Is that?
Yep, it's on page 2, line 24.
Mr. Chairman.
Go ahead.
Representative, thank you. Yes, I see that, and thank you, Mike. So, but basically, this is only during the conviction. So once they've served their time or probation or anger management classes or whatever the court has ordered them to do, then this order in Senate Bill 192 would be lifted.
Correct. This bill does not impact law-abiding gun owners. These are individuals who, by federal and state law, are prohibited from purchasing and possessing firearms for a certain period of time, at which time they will be able to, once again, purchase and possess firearms.
And thank you, Representative, for your knowledge on Senate Bill 192. Thank you, Mr. Chairman.
Other questions? Not seeing any. We'll move on to our next one. Kansas Senator Hosher. Did you bring testimony? Okay.
Good morning. Thank you so much for providing the opportunity to testify. Chair Olson and members of the committee, I am here today to urge support of SB 192. This bill is a common sense measure that would help protect victims of domestic abuse, most notably women. However, there's another segment of our population that deserves protection from domestic abusers, and it's offered through this bill: law enforcement officers. Domestic violence calls are one of the most deadly situations to which police officers must respond. A U.S. Department of Justice study illustrated that 40% of officer deaths are the result of responding to a domestic violence call or situation. In fact, in recent years, such calls have alternated between the top and second leading cause of death for police officers. Most of these shootings happen in close range, usually less than 50 feet. Our law enforcement officers put their lives on the line every day. They shouldn't have to put themselves in harm's way when there is a known identified risk. There's no justifiable reason to protect domestic abusers. Additionally, there's no justifiable reason to protect potential cop killers. It's time to join with the nearly 24 other states in the country to enact this reasonable measure. Keep in mind, domestic abusers aren't just dangerous for women, they're deadly to cops. Join me in supporting this bill and backing the blue. And you will see I include a couple charts for you on the front page that show some of the variances between where domestic violence has impacted our law enforcement officers.
Questions? Senator Hildebrand.
Thank you, Mr. Chairman. Senator Holscher, thank you for the testimony. What are the two methods of turning in your weapons in the bill?
Outlined by what the revisor indicated.
Go ahead, Mike.
It's on page 1, 18 through 20. Relinquish all firearms in the defendant's custody, basically to the sheriff or to a licensed federal firearms dealer. There is a provision in here where you are not going to get your weapons back where they actually sell them, and I assume that's why you'd give them to a federal firearms dealer, because you think you'd get a better sale price, but that's...
Isn't there a spot where if you're not there after the 48 hours, law enforcement's called to the home to pick up the... That's what I was trying to get at.
Basically, it's on page 1. If the defendant is not physically present in the court, the order shall be personally served on the defendant by a law enforcement officer, and so on, in accordance with the procedures that are outlined in Chapter 60. Anyway, if it's personally served on the defendant, the law enforcement officer shall require the defendant immediately to surrender the firearms and so on.
Thank you. That's what I wanted to bring out. Giving your testimony that 40% of law enforcement officers are in danger of when they go and pick up a weapon or domestic abuse, and since we're all enthusiastic about backing the blue, do you have any concern that we're putting officers in danger by asking them to go pick up these weapons?
40% is not relative to being called to go retrieve said weapons. That 40% is in regard to calls specifically for domestic abuse situations where you have an individual who is an identified risk that still has the firearms in their possession.
Correct, but this bill identifies that risk, that person that's at risk of doing that, and we're asking law enforcement to go to that home of that person that is identified at risk to pick up those weapons. So what, you don't have a concern with that?
Well, no, but that is a totally different measure that you're looking at, as far as you would need statistics in regard to incidences that occur as a result of going to the house to get the weapon, which that doesn't measure as far as being an identifiable cause of a police officer's death. Additionally, when you're talking about a domestic abuse situation and those calls, they tend to be pretty heightened as far as stress levels, angst, that type of thing. So you're entering into a situation as a law enforcement officer that is likely escalated, very concerning situation. So that's why if we have the opportunity to not have the firearm in the domestic abuser's hand at that point, that's where this helps and makes the difference.
So serving a restraining order on someone that is highly likely to be a domestic abuser, and then notifying them that they are going to lose their weapons and a law enforcement officer is going to come pick them up, that's not a heightened security risk?
Does not come in the top numbers as you see on the chart. It does not register as one of those leading causes.
How many laws allow law enforcement to go and confiscate a gun from somebody?
You have to ask the revisor. I don't know. how many do, but you'd have to ask him.
In terms of a law authorizing confiscation of weapons and so on, in terms of actually physically going to, I'm not aware of any that are as specific as this. Confiscation of weapons is provided for in different statutes, but not sending the law enforcement officer out to get them.
So therefore, we wouldn't have statistics on that. Thank you.
Other questions? Senator Fasquedo.
Thank you, Senator Cindy Holscher. Thank you, Mr. Chairman. So I would draw your attention and the committee's attention to page 9 of Senate Bill 192, particularly in the lines 27 through 43, 44 lines, that would be new language in the bill. And so as I read it, we're talking about an individual who, after an order of abuse, or this order has been made upon them after the court hearing, and so at that time they're told, you need to do this. So therefore, they already know, because that's part of their sentence after abusing someone, physically abusing their spouse or children in the presence of that domestic violence abuse. So then they go to court, and perhaps when the police came in the first place, the police saw them with a handgun. You know, they arrested them, you know, and a handgun was found at the scene, and maybe so maybe that gun is already there in the courtroom as evidence, and then the order is made against that perpetrator who committed the abuse. So to Senator Hildebrand's question or point, so wouldn't you say that perhaps it wouldn't be as many law enforcement put in that danger of going to remove the firearms if that person convicted and ordered to relinquish does not, you know, they're going to voluntarily do that because the court has ordered them to do it. They've been convicted. So do you have any evidence, or anyone that's going to be a proponent or speak on this, to how this has worked in other states, how it has benefited both law enforcement, the person who is abused, and the abuser? Thank you, Mr. Chairman.
Excellent points. Thank you, Senator. Yes, you're absolutely right. In most cases, the weapon is going to be relinquished at the time when it's being held in evidence, after the case has happened. So you're right. Additionally, when you're talking about the instances of a person, of a law enforcement officer going to a home, it's a little different circumstances than being called on a domestic violence call. I mean, you don't know what exactly is going on there. You are not in control of the situation at all. When you, as the person, are going to the house to do that, you know, to do the confiscation, it's a little different dynamic. But you're absolutely right. In most of those cases, you know, the weapons are not relinquished at the home. It's through the court process.
Senator Hildebrand.
Thank you, Mr. Chairman. Not a question, just a comment, but very few gun owners only own one gun.
Absolutely.
Okay, further questions? Not seeing any, thank you. Lindsay Ford.
Hi, I'm Lindsay Ford. I'm the public policy attorney with the Kansas Coalition Against Sexual and Domestic Violence. We're a statewide agency made up of 25 member programs that represent survivors of domestic violence and sexual assault across the state of Kansas. Very excited to be here today talking about this bill because it provides a really unique opportunity that we don't often see in legislation to enact a law that would directly affect survivors in a sense that it could immediately save lives, like not tangentially create circumstances in which it would be easier for them to leave or safer in the long term, but have an immediate effect of providing life-saving mechanisms for victims of domestic violence. Removing firearms from someone who has been adjudicated to be a threat to members of their family, to their spouse, to their children, removes a danger of long-term potential lethality. I've included several statistics in my written testimony that for brevity's sake I won't repeat here today because I'm sure nobody wants me to do that, but I would encourage you to read the written testimony that I provided. I do want to draw your attention to the fact that the KBI has specifically reported that there is a reported domestic violence-related death in the state of Kansas every 10 days. And that is from data gathered in 2020, which was after the enactment of the law in 2018 that we're trying to create a mechanism for enforcement here today. So the 2018 legislation was a significant improvement in acknowledging the fact that firearms in the hands of a credible threat continue to pose a risk to survivors, but we don't have a mechanism for enforcing it that actually would allow citizens of Kansas to be protected from those threats. I also, real fast, want to correct my written testimony. I reported in there that 14 deaths had occurred so far this year that were attributed to domestic violence homicide. Since the submission of my testimony, there was a killing in Lenexa. 3 people were shot and killed. That has subsequently been ruled to be a domestic violence homicide. So it is now 17 in the state since the beginning of the year, not 14. And again, those 3 additional deaths were from gunshots. So this bill is not unique in the fact that this is an issue we've talked about many times over the years. And again, we've passed legislation trying to enact ways to protect DV survivors before. This just creates a mechanism for enforcing the current law, both the federal law and the Kansas law. And it allows for everyone to really understand the process. I can't tell you how many phone calls I have taken over the last few years from survivors who have a qualified protection order where their batterer has been adjudicated to be a threat, and they don't know how to get the firearms out of their hands, how to keep the guns out of the homes. And there's really not an answer because there's not a system in place for enacting that. And it's very hard to explain to a very terrified person that there's not a whole lot that can be done, especially when it's literally their life at stake. So this would absolutely go a long way towards keeping a lot of people safe. I also just want to take a moment to point out that the process that is outlined in this bill involves a lot of service, a lot of process for the person whose firearm is being implicated. Qualified protection orders require personal service and a specific finding from a fact finder, a judge, that this person poses a credible threat, not just to potentially a spouse, but also to a child. There have also been, of the 17 killings that have taken place this year, there's been more than one that has involved the death of a child. So those are things that we want to think about. When we talk about domestic violence homicides, we're not just talking about grown-ups, adults, we're talking about children too. And this would create, again, a mechanism by which we could keep everyone safe. So as I'm sure you'll hear from other conferees, and I think as the legislators all alluded to, domestic violence continues to be a significant cause of death in the state of Kansas. And not just for women and children, but for batterers who have access to firearms and choose to take out their families and themselves at the same time. And this bill would really go a long way to addressing that issue and keeping people safe. And with that, I'd be happy to stand for questions at the appropriate.
Okay, we're going to hold questions until the end of the proponents. So, Latonya Boyd.
Good morning, Chairman Olson, committee members, and staff. Thank you for hearing my testimony today. My name is Latonya Boyd. I live in Topeka, Kansas, and I'm here to tell you why Senate Bill 192 is important to me. Taisha McNair was my 21-year-old daughter who was shot multiple times and killed by in a domestic violence relationship that she was trying to leave. She never had that chance to. And I'm trying not to cry.
Take your time.
Taisha was my very first daughter. We didn't always get along, but she was my left-hand chick, as I called her, because she was always there with that left hand out. Taisha had two little girls who never got to see them do anything because she was killed. Granddaughter, Coriana, 3 years old, she wanted to know why her dad would do that to her mother. I said, Coriana, I cannot answer that question for you. That is going to have to come from him. Well, that never came from him. My life has been changed forever. This bill is so important to me. Every time you guys have a bill that relates to domestic violence or gun violence, I'm going to be here. He should not have been able to have a gun. He was arrested for domestic violence. And this Senate Bill 192 will keep so many women and children safe. So I am in support of this bill, and you guys should be in support of it too. Thank you for giving me this opportunity to talk.
Thank you. Leanna Barker.
Good morning, Chairman Olson, committee members, and staff. Thank you for hearing my testimony today. My name's Leanna Barker, and I live in Shawnee, Kansas. I'm testifying today in support of Senate Bill 192. Currently, Kansas state law prohibits most domestic abusers from possessing firearms. The problem is, even though the convicted abuser is prohibited from purchasing a gun, there isn't a law requiring them to turn their guns in that they already have. So basically, the current law is toothless, providing no mechanism in which to enforce the law. Senate Bill 192 would fix this glaring loophole. This bill would give law enforcement the tools they need. Convicted domestic abusers would be required to turn in their guns while they are prohibited from possessing them. The statistics on domestic violence are very clear. A woman who is in a domestic violence situation is 5 times more likely to die when a gun is present. In fact, 70% of all women killed by intimate partners in Kansas were killed with a gun. This bill will save lives. We all are aware of the stress of the last 2 years. There has been a significant increase in calls to domestic hotlines during this period. Certainly, it is more important than ever to pass this legislation. As the Irish would say, it's not before time. In fact, I would say it's several years overdue. In 2018, the current anti-domestic violence law was passed with overwhelming bipartisan support. Legislators of both parties acted to keep the women and children of Kansas safe. And it's time to strengthen this action and give our law enforcement the means to reduce the tragedy that is domestic violence in the state of Kansas. I urge the members of this committee to support Senate Bill 192 and vote yes on this life-saving bill. Thank you.
Thank you. I have several other written proponents. With that, we'll go ahead and open it up for questions. Do we have questions for the proponents? Senator Fascodo?
Thank you, Mr. Chairman. Mr. Chairman, when you and I first went to the Senate from the House, one of the first bills that I introduced was relating to domestic violence. And it's unfortunate, I remember one of my colleagues saying, oh, this bill is not needed because the women usually go back to their spouse. And so I just want to say to the last proponents that just testified, Leanna and Latoya, I think I've seen you here in the building ever since I've been in office, and so I appreciate your continued advocacy for this issue. My question, Mr. Chairman, though, it would be for Lindsay Ford. As you approach the podium, Mr. Chairman, committee, I was appointed by the Attorney General, Derek Smith, to serve on a state domestic violence board to look at some of these issues and look at funding. And Mr. Chairman, over when we were first shut down with COVID, I was getting phone calls from the Wichita Crisis Center and from individuals in Cedric County and Wichita sharing with me that women who were in domestic violence situations and guns were involved, so the police would show up and just tell the woman to leave and go to a shelter. Our shelters were really full at that time. And then to further impact that situation, Mr. Chairman, those women, when the federal level first sent our stimulus checks, those women who were married and filed jointly, they socked it to them even more. They were battered at home, and then the husband or the spouse or the perpetrator was allowed to get that full refund. So the women didn't even get that funding at all, and then they suffered the abuse. So in your testimony, Mr. Chairman, if I may, in your testimony, Ms. Ford, it says something in here about the relinquishing part from the federal level is already in place. Could you elaborate on that piece just a little bit of? Yes, thank you, Mr. Chairman.
Thank you so much for the question, Senator. And yes, there were a lot of really horrible complications that came about during the beginning.
So it's on the first page. It says it's the third paragraph.
Yes, so currently our federal statute, specifically 18 USC 922, creates a mechanism, a requirement by which someone who has been convicted of misdemeanor domestic battery or someone who has a qualified protective order should not or shall not be allowed to possess a firearm. And so that is what the 2018 legislation attempted to enact here in Kansas. We just, as I think was testified by many people, don't have an enforcement mechanism for it. So technically we have the statute, we just don't have any way to enforce it.
Thank you, Mr. Chairman.
Okay. Other questions? Not seeing any. We'll go ahead and move on to the opponents. Sheriff Jeff Easter.
That's my sheriff.
Okay.
He's the best in town.
Good morning. Welcome. I appreciate you giving us the opportunity today to speak. My name is Jeff Easter. I represent the Kansas Sheriff's Association. One of the things that we want to make sure that everybody's aware of, we and the members of the KSA have been supporting domestic violence victims for years, providing advocates within the office to assist domestic violence victims throughout the court process and other needs that arise. What we're testifying to here today is some of the issues in this particular bill. I will tell you, throughout my career, starting in 1989, domestic violence has been an issue within the state of Kansas, and particularly in the Wichita-Cedric County area where I worked for years. And I've seen those tragedies for years. I've seen women that have been shot, have been stabbed, beheaded, those type of things. They're huge tragedies. I will also tell you that there has been a big incline on what we do for domestic violence victims. In 1991, some laws were passed because before that, if they didn't want to prosecute, we couldn't arrest. And so it caused us as law enforcement to see folks that have been battered, bruised, and they're scared to death that they didn't want to prosecute. So it would cause us to do some things with the suspect to get them to swing at us so we could take them into custody, because to get them out of there and to get that victim some help. Luckily, the laws have become to the point where we don't have to do that anymore, and they keep growing, which is a good thing. However, we do believe there's some problem provisions within this bill as it's written. On page 1, sentences 18 through 20, relinquish all firearms in the defendant's custody, control, or possession of the sheriff of the county in which the court issuing such relinquishment order is located, or to a licensed federal firearms dealer. There is a court case called Henderson versus United States, a Supreme Court case in 2014, that we think that this could cause problems with that particular court case. In Henderson versus United States, the opinion provides the federal government must allow a convicted felon who possesses a firearm to transfer the firearm to a recipient who will not grant the felon control over the firearm, which would include a firearms dealer. It also provides we must allow the owner of the firearm to transfer ownership if they desire. In this case, the Federal Bureau of Investigation wanted to keep the gun, and this decision made it clear they could not. The firearm had to be turned over to a second party to include a federal firearms dealer. Because of that, and I understand that is for people who are convicted of a federal felon or of a felony. This is different. It's misdemeanor, but it's still relinquishment. So we think there might be some problems with how that court opinion has viewed relinquishment of firearms. On page 1, starting on line 24 through 27, requires the defendant, if physically present in court, to comply with the provisions in subsection B within 24 hours of such order is entered. Again, we believe this is a violation of Henderson versus United States and should be given to a third party or a licensed federal arms dealer. On page 2, starting on line 11 through 13, discusses the law enforcement officer or a licensed federal arms dealer shall issue a proof of relinquishment to the defendant. We already have forms that we give people when we seize evidence from them, such as a search warrant. We don't believe that there needs to be another form because it's the same form we use when we take anything into our custody. We also must point out, throughout the bill, there are inconsistencies on which law enforcement agencies will do what. In some areas, any law enforcement agency may take action. However, on relinquishment and storage, the bill only states sheriffs are able to fulfill the proposed statute language. The KSA would propose that underlying domestic violence convictions, whether in municipal or district court, should be tasked with carrying out the relinquishment order. So if there's a DV convictions in the city of Wichita court, they're the ones that should have to take that firearm. It should not all fall upon the sheriffs. The other thing that I would add, I think a misconception is if they don't show up within that 24 hours to relinquish that weapon, they're not voluntarily doing it then at that point. And so at that point, law enforcement will go out, and because we have a relinquishment order, we don't have a search warrant, and we're talking about search and seizure at that point, does not allow us to go into that house if that person says, you're not coming in my house. So then we have to build probable cause to say that there is actually a weapon inside that house at that very moment. So there is an avenue to do that, and it's going to be with probable cause and with search warrants, but I don't want to make people think that just because we have this relinquish order, it gives us the right to enter into their house and search it, because it does not. And I'll stand for any questions now or at a later point.
Okay, I think we'll hold questions. Ed Clump.
Thank you, Mr. Chairman, committee members. My name is Ed Clump, and I'm here today speaking on behalf of the Kansas Association of Chiefs of Police and the Kansas Peace Officers Association. We oppose this bill simply because of several concerns we have in it. I want to just point out that in our testimony, we kind of divided this into sections. Our practical concerns of the application of the bill, the legal concerns, law enforcement, logistical, and operational concerns, and then finally in the fourth section, we offer three other solutions that we think would probably be more effective than this bill would be to address the problem. So I want to go back. There's been a lot of talk about the 2018 bill that was passed that added the provisions in our state statutes prohibiting persons with the protection orders and with the domestic violence convictions that are addressed in this bill, placing them into the statute that prohibits persons from possessing a firearm. So we have a law already that provides that the persons this bill is addressing are forbidden to possess a firearm. And that is a severity level 8 felony. So I've heard a lot that there's no enforcement mechanism. There is. I assure you we have made numerous arrests for people under these provisions since it was passed. And there is an enforcement mechanism there, and it does create a felony charge. Even if the base reason that of the conviction was a misdemeanor, the fact that they possess a firearm while the person is prohibited as a severity level 8 felony. Like the sheriff said, we're well aware of the frustrations that both survivors and victims and family members have with the inability to absolutely protect people after these incidents occur and during these incidents. It's frustrating for us. It's frustrating for them. But we just don't think this is the right solution for that. So one of the differences between what the bill does and what the law currently does. So under the law, the person's prohibited. And if we have information that a prohibited person, doesn't matter for what reason they're prohibited, is possessing a firearm, we investigate those. And we try to get probable cause to go and search and find if that, that the weapon that person is possessing. But like the sheriff said, we have to have probable cause to do that. And it has to be not only probable cause that the person is possessing the firearm illegally, but they have to have probable cause that a crime is being committed, has been committed, or is about to be committed. And we have to have probable cause that that weapon is at the place that we're seeking to search. So I heard one of the people testify that if you had a person who at the time of the domestic incident had a firearm, then, there would be reason that they have a firearm after conviction. Well, that conviction may happen 3 months later. And I assure you that will not stand up for probable cause. We have to know at this time that person is in possession of that firearm against the law. We're concerned that this avenue is going to create a lot of expectations that it can't fulfill. We saw the same thing happen with protection orders. People are under the feeling that I have this protection order, I'm safer now. And we know in reality, they're really not. The protection orders get violated frequently, and we have a law for that. And we arrest them on new charges. It's not just picking them up and revoking a bond. There are new charges when they violate those protection orders, and we enforce that on a very regular basis. In the legal concerns, one area I'll point out is on page 2, lines 40 to 41. It has a provision in there about the court clerk notifying the sheriff they need to take some specific legal action. I don't think that's really the way our system works. The court can order us to take legal action. I don't think the court clerk can. I mean, this is just a notification, but then as a result of that notification, the bill states we're supposed to take certain actions. So I think that's something that is amiss in it. So one of the things in the bill that we think is a good idea is it requires the court to put the person on notice at time of conviction or time of the issuance of the order that they are prohibited from possessing a firearm. Now, the bill wants us to place that into a relinquishment order, but it's not a bad idea for courts to do that, and I suspect many of the courts do. I'm not sure if statutorily they're required to or not, to put that person on notice. You are not allowed to possess a firearm, and if you do, you're committing a felony. And even many times, most of the time in these cases, even the bond condition has a prohibition about possessing firearms. And so even be put notice on that. So those are a couple of things that we see in it that we think are good. The searches, the sheriff kind of covered that. It's just not as easy as this bill makes it sound. And we do those when we have evidence of that and we build probable cause. Sheriff mentioned Henderson versus U.S. I'll point out a couple of things in the bill that I think might be problematic. Page 3, lines 29 to 34, provides a sheriff may dispose of any firearms, and we assume eventually this will be law enforcement can dispose of any firearms relinquished by a defendant pursuant to a relinquishment order issued under subsection A2, only after the defendant is notified of the pending disposal of such firearm. So we only have to notify them of the disposal. And Henderson says we can't deny that person of their ownership rights to that firearm. You can take away their possessory rights, but you cannot take away their ownership rights. And so we have to, under Henderson, provide them an avenue that they can dispose of that firearm in a way to recover their money or to keep it in some fashion where they're not in possession of it until they're allowed to have possession of it again. And we think that probably violates that. There's also a provision on page 3, line 35 through page 4, line 3 that's questionable under Henderson that has to do with the return of the firearm to the owner if we determine who the rightful owner is. But it has a condition in there in subsection K1 that I don't think under Henderson we can lawfully impose on that owner of the firearm before we give it back to him. Then in section 1 on page 1, line 9, it talks about the relinquishment of the concealed carry license, and it says any concealed carry license. I think you all could pass a policy that law enforcement could, in certain cases, confiscate a Kansas concealed carry permit. I don't think you have the authority and the legal ability to have us confiscate another state's permit. I just don't think that lawful authority exists. And so that's kind of a problem also. So our logistical and operational concerns, we are told by our agencies now our firearms evidence lockers are full. And they're full of firearms that are evidence in crimes, things that we must retain. And to add this additional burden of really actually storing firearms that have not been involved in a crime at this point, it is a burden on us that we think is not realistic. It's expensive. There are laws that we have to maintain property in the condition we receive it. And I tell you, give a firearm back to a person who is a very fond supporter of the Second Amendment, and their gun has a scratch or a piece of rust on it, they're going to let you know about it. And any of us that have firearms, you know that you can't just take a firearm and stick it in the closet for 3 years, and it's not going to come out the same it was when it went in. And so they require constant care to do that, and that's expensive. I think I'll just stop there, Mr. Chairman, and answer questions. I would point you to the last section of our testimony. We do offer 3 things that we think are gaps in current law that we frequently see in these cases. You know, people have protection orders, and we see violations of those protection orders once, twice, 3 times, and the person simply released back out on bond. Some of them are on bond more than 1 time at the same time. And we think those are some of the things that need to be addressed. So I'll stand for questions.
Okay, thanks, Ed. I think we have one more that want to testify. Greg, do you want to? Yeah, okay.
Thank you, Mr. Chairman. I'm Greg Smith. I'm the Special Deputy for Government Affairs with the Johnson County Sheriff's Office. Just as a point of information, we are members of the Kansas Sheriff's Association and agree with their testimony. The testimony that I submitted to the committee yesterday morning basically divides my testimony up into 2 areas. Legal concerns, almost all of them have been touched on by those who went in front of me. The big one is the Henderson case, the Supreme Court case. It's definitely going to impact this legislation. The other issue that we have, or concern that we have from a legal standpoint, is the bill would require relinquishment to the sheriff. What happens if the if the order is from a municipality. What happens if it's a domestic violence case that's heard in the city court? That's not our jurisdiction. That's the city's jurisdiction. So there may be some issues there as well. And again, you heard the concerns about concealed carry licenses and being able to confiscate those. From the operational concerns, you heard about storage of the weapons. We have property rooms, evidence rooms. That's what they're for, is to store evidence. If we have to store additional firearms on top of that, our evidence room is already busting at the seams. And this is just going to require more maintenance on our part, more man hours on our part. You can't just stick a gun in a closet and leave it there. It's got to be maintained. It's got to be examined, make sure that there's no damage to it. As one of the previous opponents said, there are folks that get a little upset if their favorite firearm or their grandpa's heirloom is all of a sudden not in the same shape as when they got it. Also, in talking with our deputies, some of them are concerned with the term good faith effort that's throughout the bill as far as us making a good faith effort to locate a firearm. As you heard, we're constrained by the Constitution and state law on what kind of a search we can do based on the circumstances. Can't just walk into somebody's house and say we're going to look for weapons today. That's not how it works. Finally, this is at least, I think, the third time in about as many years as this exact same bill, worded the exact same way, has been in front of some committee somewhere under some bill number. And each and every time, opponents have come in and explained the areas of concern that we have with the bill, and I've yet to see a single amendment done. So we're asking you to please listen to us. These are valid concerns that could adversely impact what folks want this bill to do. The expectations, I think, exceed what the realities are, and we need to make sure that we work for something that can actually work. I'll give you a couple of examples here to close, Mr. Chairman. I think our most recent case that falls under what this bill describes, someone that was convicted of domestic violence. They were placed on house arrest with an ankle bracelet, and they went to their home. The other person, the victim in this case, lived somewhere else. The convicted domestic violence person cut off their ankle bracelet, went over to where that person was, and strangled them to death. This isn't going to do anything to stop that. The other major one that we had, I had to go all the way back to the 80s. We had a gentleman, same thing, and it was a restraining order, protection order. Left the courtroom, went out to his car, got a firearm, waited for his wife to come out, shot her right outside the courthouse. I just don't want, keep in mind that the sheriff's office, we see this stuff all the time, and we're very sympathetic to the victims. I just don't want people to have a false sense of security about what this bill can provide. I'll be happy to stand for questions.
Okay, questions for the opponents? Senator Straub.
Thank you, Mr. Chairman, and I just want to say thank you to all of the law enforcement officers that came to testify in opposition of this bill today. And thank you for not only protecting our individual right to bear arms, but for also I want to thank you for protecting the public and for your excellent testimony on this bill. And I just want to ask, are there any suggestions that these law enforcement officers would have that could improve safety? Are there things that the law does that might provoke the aggressors in these cases? And are there things that we could do to help ease some of that aggression?
Anybody want to take that? Ed?
Well, I'll jump up and speak to that since I did put in our testimonies 3 recommendations we had. To speak directly about, is there something in the law that provokes people? Probably. I mean, people that violate the law seem to get provoked when we enforce it. I don't care if it's a speeding violation or, you know, shooting at somebody. They seem to not take kindly to us enforcing it. But at the same time, one of the things this bill does is it takes the firearm away from even the possessory right, even when there has been no firearm used in the crime, even when there's been no threat of a firearm to be used. And in the case of a domestic violence conviction, there may not even be further physical threats made. Now, the protection order can only be issued if the court finds there is evidence of physical threat. And so if you have protection order, that's a little different. But I can tell you that if you want to aggravate people, take away their constitutional right of possessing or ownership, not possessing, their ownership of a firearm, and go in and forcibly remove those firearms, yeah, we're going to have confrontations with somebody over that. Hopefully most of the people will understand we're following the law and we're doing what the law said if something like this would pass, but undoubtedly there would be that confrontation.
Okay. Thanks. Further questions? Senator Fasquedo.
Thank you, Mr. Chairman, and I'll be brief. I just want to say thank you, Ed. He's so knowledgeable of a lot of issues that we deal with in this building. My question would be for my sheriff, Sheriff Jeff Easter, but as he's coming to the podium, I want to say that, you know, this bill is geared towards saving lives. And when we talk about protection of gun rights, it's important. But also the protection of saving lives is definitely important. Mr. Chairman, I remember one night those same ladies were in the gallery of the Senate all night sitting up there. And when they left, one of them left and was killed in a sand or a dust on the highway, you know, advocating to save lives. She lost hers. So I'm hoping, Mr. Chairman, that we can take the suggestions that Ed Clump has made and our former colleague, Senator Greg Smith, has made and do something to help save lives. And so, Sheriff Jeff Easter, you know, I talk to you, it seems like he takes my calls at 2 o'clock in the morning. Mr. Chairman, a constituent will call me and they're like, oh, I think my family member's in the county jail, but nobody's telling me. And he answers my phone and I just think I'm the only one in the world that he talks to. Sheriff Jeff Easter, currently what is done now, and I know you can't speak for our police department, but for the sheriff department in Wichita Center County. So you show up on a scene, domestic violence is going on, the perpetrator is waving a gun. What do you do now in that situation? So they're waving the gun. So they go to court. Do you take the gun? I mean, what do you do now?
If a gun is involved in the crime itself, it's taken as evidence. There are cases where the mainly male half, is arrested, and the female half wants us to take the gun. However, it was not used in anything. They're more afraid of what this person might do to themselves when they get out. Our suggestion to them is involve a third party, get parents involved, family or something, to take that gun for safekeeping. So to answer your question, if it's involved with the crime itself, it's evidence that will be presented at the time of trial. And so we hold on to those.
Okay, Senator Hosher.
Thank you, Chair. Thank you so much for the work you do. Thank you for being here and providing feedback. I'm very much willing to sit down and talk with people because you've brought some great ideas, and there's more data since the first time that, you know, some of these bills were drafted. And so my question is, should I work directly with the best sheriff, or was that the title, the best sheriff?
Yeah, no, it's not. But,
no, we're going to have to talk about it.
Yeah, everybody has their favorite sheriffs in the room. So, you know, in my written testimony, I said we would, KSA would be willing to sit down with you to work on amendments to the bill. And Ed's here, he can speak for himself. But normally what happens when we offer that, Ed and I, and then a representative from the Chiefs Association will be happy to sit down with you and work through some of the language.
Yeah, no, Thank you for your service. Thank you.
Senator Peterson.
Thank you, Mr. Chair. My question, I believe, is for Ed. It'd be quick. I think I read in your testimony that you were talking about the Attorney General's Bill 534, where the increased penalties for people who actually violate the protection orders. Would that help this situation?
I think it will. I need to look at that a little closer, but certainly it could be included to help this situation. And the point I made on that is that if you have a person who violates a protection order, we have basically one penalty for that. I think it might step up after a certain number of times, but if you have a protection order and that person violates that protection order, they can violate it in a lot of ways. They can violate it just by having a presence around that person. That's one level. Another level is where they have a presence around that person and they make threats, and that ought to have a different response. And then you have those that violate that protection order. Well, they display or make threats with a firearm. That ought to raise it to a whole nother bar. And right now, I don't think we have those kind of graduations in some of these laws that could be used. I know we have a lot of cases where bad things happen in these domestic situations in the process where a person has violated protection orders over and over and over again, and no significant penalty has been dealt out to them. And they're still let out.
Thank you.
Okay, one final opportunity. Any further questions? Not seeing any. We'll go ahead and close the hearing on Senate Bill 192. Okay, we're going to start working some bills. Oh, yeah. Senator Fascodo has a bill to introduce, so go ahead and give us the RS number.
Thank you, Mr. Chairman. The RS number is 3433.
Okay, give us a little
An
description.
act concerning driver's licenses.
Okay, any questions? Any objections? The bill's introduced. Okay, we'll go on. Now we're going to work some bills. Let's start with 439. Mike, can you give us an overview of 439? I don't think so. Yeah. Yeah.
No, it's the registration.
Registration.
Confirmation.
The confirmation. It's 439. You got the wrong folder? Actually, we can start with actually 482 if you want. I think you have that. Yeah, just a brief overview so everybody can remember.
Bill basically deals with government contracts, and it enacts the Firearms Industry Non-Discrimination Act. And what it does is it prohibits the state or local units of government from entering into contracts with companies that discriminate against businesses that are involved in the firearms industry. So that's
okay. What is the pleasure of the committee? Senator Peterson. Okay. What? Senator Peterson's offering an amendment. Thank you. Looks like a pretty difficult amendment. Go ahead.
Missing one piece, but that's okay. We'll move forward with this. I can explain it is to bring in shotgun shells into this. The amendment I requested was to add in cartridge case, shot, comma, wad, comma, and there needs to be a comma between primer and bullet.
Okay. Questions on the amendment?
That would be the amendment. It's just like you see it, except with an additional comma between primer and bullet. That would mean it would cover all ammunition, rifle, pistol, and shotgun.
Question on the amendment? First, do I have a second on the amendment? Senator Hildebrand seconds. Peterson made. Questions on the amendment? Not seeing any? All in favor, please signify by saying aye.
Aye.
Against, nay? Passes. Okay, let's go ahead and then discuss 482 as amended. Go ahead. Senator Fasquino.
Mr. Chairman, and I don't know if you'll allow him to. So Tom Witt testified neutrally. Did you have an amendment?
No, Senator.
Okay, thank you.
I made some suggestions in my testimony, but I don't have a full.
Okay, thank you.
Okay. What's the committee want to do with 482 as amended? Pleasure of the committee. Senator Hildebrand?
Thank you, Mr. Chairman. I move that we pass out Senate Bill 482 as amended favorably for passage.
Got a second by Senator Peterson. Any questions or comments? Senator Hoster.
I appreciate the spirit of this bill. I am very concerned, as from the testimony provided, that this opens this up to lots of legal challenges and what that means in terms of fiscal note, revenue, that type of thing. Thank you.
Okay. Any further questions or comments? Not seeing any. All in favor, please signify by saying aye.
Aye.
Against, nay? It passes. Okay. Got one underway, so we don't have 439, or do we?
I didn't bring my bill book, but we can, I don't have any amendments for that.
Yeah, I don't think there's any amendments on it. You got the docs to do the overview, or? Here. Here, I can give you my packet of the bill.
Okay, this is a Secretary of State.
Yeah.
Bill, and basically it would add a fifth provision to where they would have to send a notice if you hadn't had any type of election-related activity for a period of a couple of election cycles. The testimony was that even with this, it would still take 7 or 8 years to actually delete the person's name from the voter registration books. This bill's been introduced in the House as well as the Senate.
Sure.
It's a Secretary of State bill.
Any questions? Senator Fasquino.
Thank you, Mr. Chairman. Mike, was that notice being sent? Was that certified, or how would that person receive that notice, or is it public or published in the newspaper?
Mailed.
So it's just first-class mail to the last known address?
Here, you need the bill? Let's see, it's
439.
Yeah, right here. Here's the whole packet.
Look on page 2 of the bill. It provides the county election officer shall send a If you look on page 2 of Senate Bill 439, you look at the subsection E at the lines 8, 9, and so on. The county election officer shall send a confirmation notice upon which a registrant may state that the registrant's current address within 45 days of the following events. And if so it adds, there's 4 provisions now where they get a notice, and the 5th provision is if the registrant has no election-related activity for any 4 calendar year period, and then it defines what that means in terms of election-related activity. The confirmation notice shall be sent by forwardable mail and shall include a prepaid, postage prepaid and pre-addressed return card in the form prescribed by the chief election officer. So that's what it states.
Yes, go ahead, Senator Fasquino.
So, Mr. Chairman, Mike, so then it gives that formally registered voter an opportunity to say they still want to vote, or Or does it just automatically delete them?
You send the notice, and they've got a return card that they can return saying, yes, we're still here.
Okay. Any further questions or comments? What's the pleasure of the committee on this bill? Do we want to work it? Thank you. Okay, on 439, do we have a motion? Oh, Senator Straub, go ahead.
Thank you, Mr. Chairman. Just one more quick question. If in between this, 7 to 8 year period, that individual would happen to go and re-register to vote, does it stop this process? Okay. So there's really no concern of the individual not being able to vote then? Okay, thank you.
Senator Hosher.
Yes, thank you, Chair. I do have a question. I don't know who, Mike, if you can answer this. Do you know if there was a reason given as far as the 4-year time period?
Why the 4th year?
Yeah, why that?
I don't know what the magic. To me, on its face, it looks like you could get it done quicker than 4 years, and the testimony was that the reality is that it would take 7 or 8 years to actually cleanse the voter roll of that name if they don't respond. So,
Senator Hildebrand.
Thank you, Mr. Chairman. And I believe the reason for 4 years was it would catch the gubernatorial and the presidential election cycle. So,
Senator Reichman.
Thank you very much, Mr. Chair. I think I understand the intent of the bill and what we're trying to do here. If a person, let's say they're upset with and they have nobody they want to vote for president, okay? And then it could be a governor, you know, in Kansas, it's be 2 years, okay? And those people, and a lot of them may not vote in local elections, okay? If they do not vote, they still, the county election order officers still can contact them and say, well, why didn't you vote? Otherwise, we're going to take you off the roll. My understanding, this is the bill. I was talking to one of our county clerks, and they're saying they really go after the people that have, you know, died or because we want to clear. We don't want dead people voting. Okay. And they're telling me how they went through this a lot. And this particular election officer said, well, one of the things, he said that there is quite a few people in that category that may not vote. They're still there. It's not ones that have moved.
Right.
But they won't vote for governor or president at that time, but they may the next time. And there also could be the same people that won't answer the confirmation, okay? Saying that, she was more comfortable if we went longer, okay, 8 years or, you know, how that number came up with. But saying that if we did pass this, and a person went through the scenario I just got you saying, and they were off or whatever it may be, I believe they still could go and vote provisionally and state that that is their residence and so on and so forth. Am I off base? Am I right or wrong? And I need some help.
Ed, Mike.
Clarification.
I believe, Senator, that was a testimony that if they showed up after they've been taken off the voter rolls, but they were at the same address, that they could vote a provisional and they would count the vote. That's my recollection of the testimony.
Senator Straub.
We could amend the bill to put it in there, absolutely, if you want. So
I'm open up for discussion. I'm trying to weed through this. Thank you.
Go ahead. I'm sorry. Are you finished? Senator Straub.
Thank you, Mr. Chairman. This question is probably for Mike. How often is it your driver's license are renewed every 6 years in Kansas for a regular driver's license, correct?
I think it's every 4 years, at least when you get to be my age, but.
Oh, okay.
I think there's some age differences at
You're right.
time. It's
Okay.
6, and then when you're, we'll say, more seasoned driver, then they take it for.
And in my experience, you're also asked, if you're registered to vote or if you'd like to register to vote as part of that process.
That's true.
So that should essentially catch anyone who just didn't vote because they didn't have a candidate they wanted to vote for. So that process alone for identification should catch those people that slipped through the system or didn't receive or didn't answer the address verification. So thank you.
I'd probably allow conceptual motion to allow them to vote, put that in provisional if they're at the same address. If someone would want to make that motion. Senator Hildebrand.
Thank you, Mr. Chairman. And Mike, correct me if I'm wrong, but on page 2, line 4 through 7, so once this is mailed out and nothing's returned, that starts the clock. They are still a registered voter until after the 8 years period. Then after the 8-year period, then they're taken off the rolls, and then they would have to do provisional. But up until the time of that clock starting and at 8 years, they can still go and vote without a provisional, and they're still on the voter rolls. So I think that takes care of your concern.
Okay.
Thank you for clarification.
Senator Fasco.
Thank you, Mr. Chairman. So to the sponsor of the legislation, what was the original reason for this?
I believe it was Secretary of State's office that, and they're trying to clean up the voter rolls, people that are not at the locations, to get them off the voter rolls. And I believe you're right. It's an 8-year period. It's actually a pretty long process. So.
Well, Mr. Chairman, from what Clay said, and I don't think I see him in the room who brought the bill forward, understanding that concern, but to me, once you register to vote, it's your right, unless you are imprisoned and you lose that privilege. And then, like the Senator Straw talked about our driver's licenses, we go and we, have to take another test or do something to for a new driver's license. But to me, voting rights is so important that I don't just want to remove people just because they decided when they first registered. When I registered to vote, there was nothing there that said, oh, well, you got to vote in every election. You've got to do this or do that to stay as a registered voter, which is my right. And so, I'm just one person on this committee. And if it passes out, I would certainly support more time, to have that right taken away from me just because I decided that I didn't want to vote in every election. Thank you, Mr. Chairman.
Okay. We're going to go Senator Longbine, and then we're going to move forward. Go ahead, Senator Longbine.
Thank you, Mr. Chairman. I think it's important for us to remember that the reason for this is not to take people off the voters' roll who are actively engaged. It's to keep the voters' rolls somewhat clean. I got to tell you, if I move out of state, I'm probably not going to remember to call the Secretary of State's office and ask him to remove my name off the voter roll. So how long and how many people do we have to keep on in that situation? Effectively 8 years, mailing them a notification, clearly without a response. The people have moved or passed away or whatever, and we can't just continue to keep those people on the voters' rolls forever if we can't confirm that they still live in the state or if they're even still living.
Well, and I think that's why the bill was brought. So with that, we've got a motion and a second. Any further comments? Not seeing any. All in favor, please signify by saying aye.
Aye.
Against, nay. It passes. Hildebrand and Peterson seconded it. Okay, that moves on. I think we'll just wait and do the rest of the bills tomorrow. We got a heavy load of bills to do tomorrow. So we're adjourned. Thank you.